Throughout this book, we have explored the theoretical underpinnings, practical applications, and potential pitfalls of blending adversarial and inquisitorial legal traditions into a balanced bench. The previous chapter highlighted many of the critiques and challenges that any such reform would likely confront, from concerns about judicial bias and resource inequalities to worries over increasing complexity or political interference. In this chapter, we turn our attention to the societal currents that swirl around judicial reform. Legal systems never exist in a vacuum. They both shape and are shaped by cultural norms, emerging technologies, economic pressures, and political shifts. Adapting a balanced bench model to this ever-evolving environment requires a forward-thinking perspective. We need to anticipate demographic changes, new forms of evidence, and the globalization of legal disputes. We must also consider the growing demands for inclusivity and equity in the justice system, demands that reflect a deepening social awareness of structural inequalities. Finally, we should explore how courts, once seen as relatively insular institutions, can engage with local communities in ways that strengthen public trust and foster justice at the grassroots level. By examining these broader social transformations, we gain a clearer picture of how a balance bench can remain relevant, responsive, and resilient in the years to come. Legal evolution in the context of social transformation. Legal institutions are dynamic entities, constantly reacting to shifts in societal values, political climates, and technological frontiers. Over the past century, both adversarial and inquisitorial systems have undergone profound reforms in response to changing social pressures, ranging from public outrage over wrongful convictions to demands for expedited trials in overloaded courts. The balance bench, as a fusion of these two legacies, stands poised to adapt more readily than strictly traditional models. Yet its success depends on policy architects understanding the societal environment in which it operates. One significant shift is the growing public insistence on procedural fairness and transparency. People want assurance that courts do not function solely as impersonal bureaucracies or elitist venues accessible primarily to the wealthy. The balanced bench offers a chance to project legitimacy by balancing proactive judicial inquiry with transparent adversarial safeguards. For instance, in a rapidly diversifying society, the notion of a judge who actively seeks the truth, rather than passively relying on parties' unequal resources, can resonate with communities that have historically felt disenfranchised or marginalized by the legal system. Yet, genuine responsiveness requires more than procedural innovation. It calls for a cultural orientation that acknowledges evolving societal norms. Issues such as police accountability, racial bias, gender equity, and access to legal representation for immigrants or refugees all press upon the justice system. A balanced bench that aims to embody both rigorous evidence testing and inclusive judicial engagement must cultivate a keen sensitivity to these shifting societal landscapes. Otherwise, it risks being perceived as another top-down reform that fails to address the lived realities of those most impacted by judicial decisions. Technological disruptors and digital evidence. Technological developments are rewriting the rules of evidence. Digital communications, surveillance data, social media activity, and biometric proofs all represent vast pools of potential information. In adversarial systems, the ability to harvest, interpret, and introduce this evidence depends heavily on the financial and technical capabilities of the parties. In inquisitorial frameworks, investigating magistrates may direct the seizure and analysis of digital data, but can be overwhelmed by its sheer volume. A balanced bench might offer a more versatile approach to digital evidence. By giving judges the power to guide preliminary investigations, the system can ensure that crucial electronic records, be they text messages, metadata logs, or smart home recordings, are diligently pursued. At the same time, adversarial challenges from opposing counsel help test the validity and relevance of these digital sources, mitigating the risk that judges rely on unverified or improperly contextualized data. Where forensic complexity is high, courts could appoint independent experts to evaluate the data, reducing the reliance on party-driven technological arms races. However, This adaptability hinges on the judiciary's ability to handle complex digital forensics. Without proper funding for technical support and training, judges and attorneys may find themselves ill-equipped to identify manipulations or hidden biases in algorithmic evidence. Moreover, the balance bench must be attentive to privacy concerns. In many jurisdictions, an individual's right to digital privacy is becoming a normative expectation, and an expanded judicial role in evidence gathering must be harmonized with privacy protections. Hence, the balance bench in a digitally driven world demands not only legal savvy, but also a robust ethical framework, ensuring that technology serves justice rather than undermining it. Addressing identity-based inequities. Discussions of judicial reform often confront the reality that certain groups, particularly racial, ethnic, and religious minorities, as well as socioeconomically disadvantaged populations, are systematically disadvantaged within the justice system. Structural biases may manifest in both adversarial and inquisitorial traditions, though they take different forms. Adversarial systems can inadvertently punish those who lack financial resources to mount a competent defense, while inquisitorial processes might centralize power in a judiciary that, if unrepresentative, brings its own unexamined biases to the investigation. Proponents of a balanced bench argue that by coupling rigorous party-led advocacy with active judicial oversight, systemic inequities can be checked more effectively. For instance, if a defense team identifies that police mishandled evidence due to racial profiling, a judge equipped with inquisitorial-style authority might probe departmental records or order an independent investigation rather than waiting for the defense's limited resources to uncover every detail. Conversely, adversarial techniques, such as cross-examination and public scrutiny in court, can challenge any judicial assumptions that might lean toward ignoring systemic patterns of bias. Still, no procedural design alone can dismantle deep-seated social inequalities. Real progress demands a broad strategy, judicial training on implicit bias, open pathways for historically marginalized individuals to join the ranks of judges and attorneys, and improved access to legal representation for the indigent. A balanced bench offers structural openings for these reforms to bear fruit. Judges have a wider mandate to explore the context of cases, and attorneys retain the right to vigorously contest all evidence. In this way, the balance bench can serve as a platform for embedding equity measures, but the ultimate success depends on whether societies are willing to invest in addressing fundamental disparities. International cooperation and globalized disputes. Modern legal disputes increasingly traverse national borders, whether they involve transnational corporate contracts, cybercrimes committed from one country into another, or human rights violations that span multiple jurisdictions. Such cases can expose tensions between adversarial and inquisitorial traditions, making mutual legal assistance or evidence sharing more cumbersome. One reason is that adversarial courts typically require parties to present evidence publicly and follow strict rules of disclosure, whereas inquisitorial systems rely on judicial authorities to gather much of the evidence in a more controlled fashion. A balanced bench might serve as a bridge in these cross-border settings, because it integrates features familiar to both adversarial and inquisitorial systems. It can more readily harmonize investigative methods with the demands of international legal cooperation. For example, if a balanced bench court orders a piece of evidence from a foreign country that uses an inquisitorial tradition, the foreign judiciary may find the request more aligned with its own legal ethos. At the same time, adversarial components, like transparent hearings and the opportunity for both parties to confront evidence, make compliance more palatable for states that prioritize open court proceedings. Cross-border cooperation thus becomes less about reconciling diametrically opposed philosophies and more about ensuring that crucial evidence is obtained, verified, and presented in ways that meet universally recognized standards of due process. Over time, as global legal exchanges intensify, courts that demonstrate flexibility and familiarity with hybrid protocols may position themselves as leaders in transnational legal disputes. This dynamic holds particular importance in areas such as international commercial arbitration, complex corruption prosecutions, and cross-jurisdictional child custody cases. A balance bench could offer a more agile response to the labyrinthine nature of global legal frameworks, easing the friction that often arises when adversarial and inquisitorial norms collide. Community, engagement, and localized justice. While much of the discussion thus far has focused on systemic and international considerations, courts also serve localized needs. From small claims disputes to neighborhood conflicts, local communities look to the legal system for resolutions that are timely, fair, and comprehensible. Adversarial proceedings often seem intimidating or overly formal to ordinary citizens, while inquisitorial models can appear remote and bureaucratic. A balance bench, by thoughtfully merging structured advocacy with proactive judicial inquiry, has the potential to create a more inclusive environment. In practice, this can manifest in community courts or specialized dockets that emphasize restorative justice, mediation, and problem-solving. Judges, empowered to explore underlying social or familial issues, can guide parties toward meaningful resolutions rather than adversarial winners and losers. At the same time, community stakeholders have confidence that proceedings will not be one-sided, since adversarial mechanisms, like counsel for each party and rules governing cross-examination, remain in place to protect due process. Such an approach can foster public trust and reduce the alienation many people feel toward the legal system. It also resonates with broader societal movements that seek to address the root causes of conflict, whether they are poverty, lack of mental health services, or substance abuse. In this sense, a balance bench need not be confined to high-profile criminal or civil disputes. It can also promote local justice solutions that unite judicial oversight with community-driven problem-solving. Adapting to rapid change. Legal systems are often criticized for their slowness in adapting to societal change. As technological disruptions, demographic shifts, and global crises unfold, courts can appear outdated, clinging to procedural rules that no longer align with contemporary realities. A balance bench, precisely because it incorporates flexible elements from two venerable traditions, may better accommodate such changes, provided that legislatures, judicial councils, and legal communities remain open to ongoing updates. For example, if a new form of digital fraud emerges that straddles international boundaries, a balance bench can respond by using inquisitorial tools to rapidly gather evidence from multiple jurisdictions while retaining adversarial review at trial. If social attitudes shift to demand less punitive and more rehabilitative approaches to minor offenses, a balanced bench court, particularly in a specialized docket, could adjust its procedures to encourage restorative practices. This capacity for procedural evolution stands in contrast to purely adversarial or purely inquisitorial models that might lack the built-in flexibility to integrate new methods of dispute resolution or evidentiary analysis. Yet, these adaptations must be carefully managed to avoid confusion or overreach. One risk is that constant procedural tinkering can itself create instability, undermining the predictability that litigants and attorneys value. A structured approach to updating the balance bench, regular intervals for reviewing rules, a transparent feedback process, and targeted pilot programs can ensure that adaptability does not devolve into chaos. It becomes a matter of striking the right balance between stability and innovation, ensuring the judiciary remains nimble without sacrificing fundamental legal principles. Public confidence and democratic governance. The ultimate measure of any judicial system is the extent to which society perceives it as legitimate, fair, and effective. In many regions, courts face a crisis of confidence rooted in fears that justice is too slow, too expensive, or too influenced by money and politics. The balance bench, if properly implemented, offers an opportunity to address these concerns by showcasing transparency, thorough fact-finding, and balanced participation from all parties. This potential, however, must be made visible to the public. While legal professionals might appreciate the technical nuances of a hybrid system, laypersons need assurance that the process does not merely result in more red tape or more judicial meddling. Public outreach campaigns, user-friendly explanations of balance bench procedures, and an emphasis on success stories, like wrongful convictions averted through proactive judicial inquiry, can reinforce confidence. Such visibility also underlines the principle of democratic governance. Courts serve the people, and reforms should be accountable to popular expectations for fairness and equality before the law. Moreover, strengthening the judiciary's accountability mechanisms, such as ethical review boards, transparent publication of rulings, and avenues for civil society feedback, can further legitimize the balanced bench in the public eye. When courts demonstrate a commitment to openness and quality in decision-making, trust in the broader legal and political system can also grow. In turn, that trust fosters social cohesion and respect for the rule of law, forming a virtuous cycle in which judicial reforms and democratic values reinforce each other. The balanced bench, at its core, is an adaptive framework designed to harness the strengths of adversarial and inquisitorial traditions while navigating the challenges of a rapidly changing world. As this chapter has highlighted, implementing and sustaining such a system goes beyond procedural tweaks. It intersects with the larger social environment, evolving technologies, shifting attitudes toward identity and equity, the globalization of disputes, and the vital need for courts to be accountable to the communities they serve. The work of building a truly responsive judicial system is never finished. Just as societal values and technologies evolve, so must the balanced bench remain open to recalibration. Ongoing dialogue with local communities, international counterparts, and academic researchers can ensure that courts do not stagnate. In this sense, the balanced bench should be seen as an ever-improving structure, not a fixed endpoint. By standing at the intersection of tradition and innovation, it holds the promise of delivering a more equitable, transparent, and resilient form of justice, one that stands ready to meet the demands of a changing world.